Your Honor, looking at the bill, there are no standards. The only
Should the bill define every term?
no, Your Honor. However, there are no, for example, for terrorism itself as a definition, there is no commonly accepted term. May I proceed, Your Honor, in order to clarify this point? Terrorism does not have the argument that such terms, Your Honor, must be understood in their, for example, natural, plain, and ordinary meaning does not hold water in this act. In Estrada versus Sandigan Bayan, no less than this court has held that a statute is vague when it lacks comprehensible standards. For example, in this case, under the plunder law, combination and series, the words combination and series, have commonly accepted meanings and can be discerned by the court. However, terrorism does not have a commonly accepted meaning. According to a report of the United Nations on Drugs and Crime, there have been several proposed definitions of terrorism, including an academic consensus. However, the same report says that the UN member states still have no agreed upon definition.
Yes, Agent, but I think the international definition of terrorism, one of the basic elements is the intent to sow fear.
Yeah.
So I think as far as that element is concerned, there is already universal consensus that this constitutes terrorism. So how can we then argue that it lacks comprehensible standards when the definition of terrorism and the basic element of terrorism would be the intent to sow fear?
Your Honor, not just, also to sow fear is also a qualifier of those what do you call this, of those acts, for example, like assassination, kidnapping. And also, aside from sow fear, it is motivated by political and religious beliefs. However, again, Your Honor, this court has also said that, if I may, Your Honor, if I think of it as a motive, rather than mere intent, it's hard to assess that because in People versus Ateneo, for example, regarding motive, the court said that it's impossible to go into the consciousness of man's mind where it is outside the observation. Therefore, without more qualifying standards and safeguards, it's violating substantive due process.
What are your proposed safeguards?
Your Honor, I believe that we are not here to, the applicant today is not here to propose the safeguards. However,
Yes, but you're arguing that
Yes.
it's vague. So how can it not be vague?
Your Honor, if, for example, they provide certain, I'm applicant, Your Honor, is not really familiar or did not go into how we may provide such safeguards or sufficient standards, but we are sure, Your Honor, that it is not sufficient in this case.
Why again is it not sufficient?
Your Honor, if I may go on to my second submission on prescription and membership, which also is couched on the definition of terrorism, then I may further your point. Is that okay? Yes.
You're saying that there's no commonly accepted definition of terrorism, but you base it primarily on this international standard, and I think the interpretation is more on the international standard, not so much on the actual definition set down by law in the proposed anti-terrorism bill. So, can you qualify for this requires all that there's no commonly accepted definition of terrorism?
I'm sorry, Your Honor.
This disregard of the commonly accepted definition of terrorism because you basically change the line what it says in the law that one second for the advanced property.
Yes.
And that's just from now, it's just restrict ourselves to this.
Okay, yes, Your Honor. Would you like me to
proceed to your argument of the
Okay, Your Honor. Applicant submits as a second point that the provisions on prescription and membership in terrorist organizations violate the rights of freedom of association and due process, the principle of presumption of innocence, and the prohibition on the bill of attainder in the Constitution. The Anti-Terrorism Act violates the right of freedom of association as provided by Article 3, Section 8 of the Constitution. And Section 17, Your Honor, of the Anti-Terrorism Act does not take into account the principle that the purpose of the organization must be taken into account in order to prescribe subversive organizations, which violates established doctrine and jurisprudence. If I may forward, the principle was laid down in People versus Ferrer. People versus Ferrer, Your Honors, of course, is where the constitutionality of the Anti-Subversion Act which outlawed the Communist Party of the Philippines and other subversive organizations, and also punished any person affiliating himself with it. While the Act's constitutionality was upheld, Your Honors, the Supreme Court laid down the doctrine that an organization's purpose must necessarily be taken into account in order to prescribe the organizations. The provisions on prescription in the Anti-Terrorism Act include not only the prescription of organizations which were organized for the purpose of engaging in terrorism, but also those, I may quote, organizations which, although not organized for that purpose, uses or threatens to use any of the acts of terrorists. Thus, Your Honors, the prescription of organizations as terrorists, even without the illegal intent, as Your Honors have pointed out earlier, to be terrorists or terrorized, contravenes the doctrine laid down by the Ferrer case, and also violating Article 3, Section 8.
So, Jason, can you just modify the latter provision and uphold the first provision?
Your Honor.
As regards to your argument on association.
Yes.
So you're going to say the first group is penalized because they have the purpose of sowing fear, and the other group will be penalized also even if they don't have that same purpose. Can we just nullify that provision and uphold the other?
Your Honor, applicant concedes that if the purpose of an organization is for terrorist attacks, that it should be punished. However, as mentioned earlier, if the definition itself is vague,
yes,
then
I said, but you haven't proven to me why it is vague.
I will further prove it to you when I further my points on prescription, Your Honor. This would inhibit, if the organizations which do not have a purpose to further terrorism also are punished, this would inhibit legitimate organizations from forwarding valid and lawful causes, only for the sole reason that they were prescribed as terrorists. Moreover, reasons other than the purpose of the foundation of the organization would warrant them to be prescribed as terrorists, such as the actions of some rogue members or their mere affiliations. While the law also provides for a judicial declaration of prescription, which it does for terrorist organization, it does not provide a remedy or a provision on deprescription or delisting of terrorist groups. Upheld is the legal maxim, mille mali species mille salutis eram, or if there are 1,000 evils, then there will be 1,000 remedies. However, the Act does not provide a legal remedy for reformatory organizations. Absent a provision on deprescription, organizations prescribed as terrorists shall forever be barred from legitimately exercising their functions as an association, thereby perpetuating injustice and infringing on the right to association. Number 3, the Constitution expressly provides in Article 3, Section 22, that no ex post facto bill of attainder, no ex post facto law or bill of attainder shall be enacted. A bill of attainder, as defined in People v. Ferrer as well, is a legislative act which inflicts punishment without trial. This, in essence,
So have you read People v. Ferrer?
I know the basic facts of the case, Your Honor.
Let's discuss People v. Ferrer for example with this. It says in your Anti-Terrorism Act, Section 17, that it should be prescribed as a terrorist when upon application to the reach of terror court. I think it's enough standards that for a person to be declared as a terrorist for you to apply to the RTC, and then the RTC will pretty much deliberate whether he is terrorist. And then I think the remedy would be the normal appeal system. So where is the violation?
If I may focus on the second part also, where organizations without the purpose of terrorist intent are also punished. In People v. Ferrer, in the same case that Your Honor has just mentioned, if the only issue to be determined, and this is why it's a bill of attainder, is whether or not the accused is a voluntary member, then the law is still a bill of attainder because it has expressly created a presumption of organizational guilt which the accused can never hope to overthrow.